zoning interpretation.
I think Mr. Hanna was going to make a presentation. Oh, is he still here? There he is.
Good evening. I apologize for the delay. I didn't know whether there's a public comment section before we started or not. This is going to be a little bit different from what you guys are probably used to hearing. Typically, as I understand it, the Zoning Board of Appeals is in discussions with developers to discuss whether or not a particular project should be allowed under zoning. And you get presentations from the developer, PowerPoint, that sort of thing. This is going to be a little bit different because for the first time, and I think this is very new and very cool, for the first time, a citizen has actually brought a challenge to the Zoning Board of Appeals to see if town conduct and town classifications for an existing project were done properly. So what I'm going to be doing is I'm going to be talking to you a little bit about the law. I've presented each of you with a handout. I'll give you a little bit of background for a little bit of context, and then to try to keep things as short as possible, we will go through the process and the decisions step by step, sort of combining what the process should have been with what the process actually was. That way, I think things will be sped up pretty well. There was a decision made in Albany some time ago that, for better or worse, it doesn't matter what you think of it, Albany decided that the landfills, the space covering landfill, including hazardous waste landfills, is just sitting out there all across the state. And they decided that those landfills could be put to better use if they had solar panels on top of them, generating solar electricity. So they wanted to encourage that sort of thing. They passed a new program and they passed a regulation to accompany that program. And the regulation was designed, like I said, to encourage it. The best way to encourage it is to get rid of the obstacles for being permitted. And the biggest obstacle is always seeker. So what they decided was that they decided to change a regulation and say that if you put solar electricity generating facility on top of a landfill, then we are going to decide per se that it's type 2. That means there's no environmental impact. You don't have to do an environmental assessment form. You don't have to go through the whole seeker review process. It speeds things up tremendously and makes things a lot less expensive. And they do that because they wanted to encourage it. So there's a company called Montante who said, you know what? We could take advantage of that plan. There's a hazardous waste site on Xerox, and if we took a whole bunch of solar panels and put a power generating facility on top of that hazardous waste site at Xerox, we could get all of the tax benefits, all of the revenue, and we wouldn't have to go through the seeker environmental process. So that's what they did. And I provided each of you with handouts. That's a picture of the site. Now, the hazardous waste site, you'll see, has blacktop over it. It sort of looks like a great big huge parking lot. And around it is a bunch of mature virgin forest, if you will. And their proposal was to put solar panels on the blacktop and to clear cut the forest and put solar panels there as well. So that's the background. What they did then is they submitted a very, very, very incomplete application to the town of Webster. And this is where we'll start talking about the process, what the town of Webster did, and what it should have done. The second page of the handout that I gave you talks about the parade of errors. The application was first submitted to Josh Artuso, but as I said, it was most incomplete. What should have happened at that time was he should have taken a complete application, made certain preliminary decisions, passed it on to the town board, where the town board looks at it and says, hey, is this something that warrants further investigation? And if so, then they vote to approve it and send it to the planning board to conduct that investigation. But if after reviewing all of the information provided a complete application, they decided no go, then the application wouldn't go any further. The problem is that Mr. Artuso sent virtually nothing to the town board. They didn't have a complete plan. They only had a concept. The preliminary decisions were not appropriately made because they didn't have a full application. In fact, when the town board decided to send it to the planning board for further consideration, the former town supervisor talked about, well, yeah, this is about putting solar panels in a field on Xerox. It wasn't a field at all, but it wasn't his fault because they didn't have any sort of information. What should have happened is Mr. Artuso should have told the developer, hold out, we're not going to do anything with the application until you give us everything we need. And only when they had everything they needed should they have sent it to the town board. Now, the town board is not faultless either. Once they got the application that contained virtually nothing, they should have said, we're not going to vote on whether or not to send this to the planning board. We don't even know what we're voting on. That's not what happened. Mr. Artuso sent the matter to the town board. The town board took the incomplete application and sent it to the planning board without any discussion, without any questions, without knowing what it was about. Now the planning board got it, and they saw that after the town board sent it to the planning board, finally Montante got all of their stuff together and submitted it to the planning board. And the next page on your handout is a letter from Montante dated August 11th saying, here's all the stuff that you guys need at the planning board to review this. And we're requiring an industrial use permit and a special use permit as is required by town law. I have that portion highlighted to you. So now the planning board at least has a full application. And what did they do with it? First of all, they only required that it be processed for an industrial use permit. They didn't require the special use permit as the town code requires and as Montante itself acknowledged was required by law. Now, because they didn't require a special use permit, there are a whole series of questions that could have been asked and should have been asked for special use permits that were not asked. And some of those considerations are attached in the handout that I gave you. It looks like this, the IN industrial project. And it lists A through N and talks about all the things that could and should be considered for a special use permit. So, under an improper classification, or at least an incomplete classification, only industrial use, not special use, it sent the matter back to the town board with a stamp of approval and said, we think that this is a good idea. Before the town board got to do anything with it, Montante made another important decision. They said, guess what? You know, all of those solar panels that we're going to put on the on the hazardous waste site, we're not going to do that anymore. We're still going to clear cut all the trees and put all the solar panels where the forest is now, but we're not going to put any on top of the industrial waste site. Well, guess what? That's the whole basis for getting the seeker type 2 classification. Without putting the solar panels on the industrial waste site, this is a a type 1 classification. They have to do all of the environmental legwork, or at the very least it's an unclassified type, and they still have to do all of the environmental legwork. What happens then is nothing. What the town board should have done is they should have said, this is a substantial change to the application that we have in front of us. Town law says that after planning board approval, if there's a substantial change to the project, it has to go back to the planning board. Substantial change is defined as a change of 10% or more. Montante admitted this was 20%. So this should have gone back First of all, they should have said, hold it, the type 2 classification does not apply. And this is a substantial change. In any event, it has to go back to the planning board. And the planning board has to ask all the questions that it didn't ask. Montante has to provide all the information that they didn't provide. Then the planning board has to vote on it, generate a report with its thoughts, send it to us for our consideration. And that's what the planning board does. It gives counsel to the town board. They didn't have any counsel. They didn't review this project. They reviewed a project with solar panels on the hazardous waste site. Now what was in front of the town board was a project without solar panels on the hazardous waste site and only in the forested section. But what did they do? They didn't send it back to the planning board. Instead, what they did is they voted on it and said, well, this is contingent. We're going to vote to approve it contingent upon having subsequent planning board approval. So they've sent it to the planning board, again, still with industrial use. The planning board should have changed the type 2 classification to a type 1. It did not. It should have said you're required to have a special use permit. Even Montante admits that. They did not do that. The town has suggested that sending it to the planning board after the town board has already acted was sufficient. Having it subject to planning board approval down the road is sufficient. We know that it's not. The law is written sequentially for a reason. As I've already stated, the town board had to have the benefit of planning board counsel, and it didn't. There was a similar situation that occurred just last year with the New York State Legislature. The state legislature decided that it wanted to present to the voters a constitutional amendment, a change to the New York State Constitution. The law says that before they can do that, before they can vote to put that issue on the ballot, they have to get a report from the Attorney General's office saying that the proposed change would be constitutional and that the language that was being proposed was reflective of the legislature's intentions. That's got to come first. They didn't wait for that. They voted on Wednesday and they got the AG's report on Thursday. And the AG's report said everything is fine, but they did it in the wrong order. And that went to the New York State Supreme Court, and the Supreme Court said, you can't do that. You have to do it in the right order. The fact that you're approving something without even having the Attorney General's report shows that you're not following the law. You're supposed to take the Attorney General's report and actually read it and consider it and factor it into your voting. And they didn't do that. The Supreme Court said you can't. Said that's no good. And they reversed it. What we have here is a project that has been messed up at every stage of the procedure. And because it has an industrial use permit only, which is insufficient, and that means that it doesn't fit under the proper zoning. It needs a special use permit, and if you have any questions about the difference between special use and industrial use, I'd be happy to discuss them. I've given you copies of each legislation, of each set of rules. But essentially what it is the industrial use permit regulations say everything that is allowed, and it's not on there. That's why you have to couple it with special use, which says, okay, if this is something that's going to be happening in an industrial lot, but is not specifically authorized by industrial use regulations, then you need a special use permit. And here are all the considerations that you have to meet in order to get a special use permit. And when the town board ultimately votes at the end of the day on whether or not to issue the special use permit, it has to go through each and every one of those considerations to decide whether the proposed project meets them. None of that happened. This approval is procedurally deficient from top to bottom, and as a result, it is also substantively deficient. It's up to this board to correct it. And that's what I'm asking you to indicate that, that this project may not proceed until it goes back to the planning board until they take the proper procedural steps. And more importantly, until they consider everything that the law requires them to consider. This isn't just an argument about technicalities. This is an argument about the fact that the things that were supposed to be considered and debated and evaluated were not. Accordingly, the town's actions have to be reversed, they have to be stopped, and they have to go back to the drawing board. Thank you.
Okay, you want me to start?
Well, is there any questions from the board? I appreciate that. Thank you.
Awesome, thank you. I'm available for any questions you may have.
Understood. Thank you.
So why don't you let me start?
Okay.
So that I can help the board decide perhaps what questions they want to ask or not ask. Sean, I'd look at you from time to time out of courtesy, but you're behind that pillar, so no, you can stay seated. I'm just I don't want you to think I'm rude.
No.
So look, as any good advocate would do, as Mr. Hanna does here, you present a mix of fact with your interpretation of the law, and ultimately some conclusions that you want the fact finder, which in this case is this board, to make a final determination, kind of just as you would if you were an appellate body or a jury. And some of you have not been on the board when we've done this before, but we have done this before. On one occasion, within the last year or so? I can't remember. And I think it was a citizen that was outside of the applicant, I want to say. So it doesn't happen often, but we have done it before. So Mr. Hanna has framed the issues a bit more broadly than what I think your duties are here tonight. Certainly an argument can be made that with respect to a determination that Josh made had a cascading effect as this thing wound through the process. However, I'm going to recommend that you focus on Josh's determination and much less so on the broadness of Mr. Hanna's representations. That may ultimately be correct, but your job is to review the determination that Mr. Artuso made. And parenthetically, I would tell you that the group that is opposing the approval that the town board made, I guess within the last 30 days, has commenced an action in Article 78 that the town board acted essentially arbitrarily and capriciously with respect to the determinations it's made, significantly based on many of the reasons that Mr. Hanna set forth. So that's as I see this in terms of setting the table. As a threshold matter, which is important here, typically, and I guess it's not so typical, as I said, we've done this at least one other time, and it may go back before my time. You would see this closer in time to the town board who ultimately might make a determinative decision. You'd hear this board, this type of appeal would be brought before this board before that time, because the statute requires that when sitting in this capacity, I'll read to you the statute, which is Town Law 267-4. It says in pertinent part, the jurisdiction of the Board of Appeals shall be appellate only, and shall be limited to, in this case, hearing and deciding appeals from any reviewing an order, requirement, decision, interpretation, or determination made by the administrative official charged with the enforcement of any ordinance or local law adopted pursuant to this article. Such appeal may be taken by any person aggrieved, which Mr. Hanna represents. So that requirement essentially is that this board needs to be placed on notice of this circumstance within 60 days after that determination has been made, in this case by Mr. Artuso. There is some ambiguity in so much as I believe the statute talks about a filing of Mr. Artuso's decision that shall be filed in the office of such administrative official within 5 days from the day which it is rendered shall be a public record. Well, we know as a practical matter that Mr. Artuso makes decisions similar to this on a regular basis, and there's no official order per se, but oftentimes there's emails or other documentation that the determination was made. In this case, we know at the very least that there was a resolution of the Webster Town Board.
I am William Gabriel, a professional basketball player, an Olympian, and a former refugee. Brutal war and violence threaten millions of innocent lives in Sudan. Every day brings more horror.
On or about July 17th, 2025, about 11 months ago, wherein that resolution contained, whereas pursuant to the Webster Town Code, an industrial use permit is required for any use within an I-N district. So the town board was acting, we know at that time, based upon an act by Mr. Artuso limiting his recommendation as to what they needed to do to just an issuance or review of the industrial permit as opposed to the special use permit or both, as might be essentially Mr. Hanna, amongst other things, argues that that is the missing link here. And the fact that that was not made a requirement caused the cascading, again, the applicant's opinion that all of these things that weren't reviewed, that should have been reviewed, that followed. And again, I'm not commenting or passing judgment as to the accuracy of that or not. So notwithstanding that, I think this board first, before it gets into the merits, and we can talk and the board can ask questions if you wish about the language, and I think it was 155.6 that talks about requirements of a special use permit for residential districts, which, as we know, this is not a residential district. But first, I think the board should make a determination as to whether this application as an appeal of Mr. Artuso's decision is timely before you to consider. If you determine that it's not, it would be my recommendation that you need to go no further. If you find that it is, then obviously the next step would be to get into the merits of Mr. Hanna's argument as to whether or not Mr. Artuso's decision not to bring that to the attention of the town board. We can obviously get into that. But I want to say that it is not this board's job to correct actions taken by the town board or the planning board. It is really narrowly on that decision that Mr. Artuso made. But first off, is it timely or is it not timely?
Counselor, would you mind very much if I address that very briefly?
Sure.
Thank you very much. As I think you suggested at the outset, I'm sorry.
Mike, yep.
I know I couldn't hear back there either, so that's why I had to creep up. I apologize.
Yes.
I think as Mr. DeMarco suggested at the very outset of his remarks, there was no official pronouncement from Mr. Artuso as to the type of permits that were going to be required. And in fact, after the town board action that Mr. DeMarco described as having occurred in July, there was still a letter from Montante indicating that they were seeking, they finally submitted the application, which had been acted on, without having received it. And when the application was submitted from Montante, Montante specifically said, we are seeking and we need industrial use and special use permits. They would not have said that if the issue had been decided, as is being suggested. It only became public. The industrial use permit component only became public on April 1st when Mr. Artuso wrote a letter to the various town board members and copied in a number of the neighborhood residents saying that only an industrial permit was going to be required, and here's why. That's when the clock started running. You start the clock running at the latest time, and that's when the clock started running. And the appeal to this board was filed within 60 days of that letter.
I don't disagree with the facts that Mr. Hanna has laid out. I may disagree with respect to his interpretation as to whether or not something being made public is what the statute requires. The statute addresses that it shall be a public record, and I think as a matter of practice, probably in most, if not all towns, that there is some type of communication made by a public official, whether by email or otherwise, because you could imagine that the amount of decisions that are being made, there wouldn't be formal orders filed with the Webster town clerk in each and every instance. And that's why I'm suggesting to you that we know that the determination was made part of the public record in the July 2025 resolution. But again, ultimately this board has to make a decision here whether, in light of the requirements, that is, in your mind, sufficient to trigger the 60-day clock, and whether that 60-day clock it has run. So, go ahead.
I'm going to just try and summarize everything I've heard.
That's usually pretty dangerous.
I'm going to try. So, as of right now, the I guess the applicant for the zoning interpretation, there is an Article 78 at this point, which has been filed. I'm assuming that will be heard regardless of anything that this board does at that point. And if I misspeak at any point, Mr. DeMarco, please stop me. This board has the opportunity to make a determination if this zoning interpretation is timely based on when the application was submitted, based on correspondence that had occurred. We could forego that, move forward with the zoning interpretation as itself. If we deem it not timely, we could stop there. Did I summarize that in a
I think that's generally
kind of a nickel?
I think that's generally accurate.
Okay. I guess questions from.
And can I just,
Please.
Mr. Hanna, that April 1st date that you've used to say it was made, quote, public,
Yes.
close quote, what document is that, or what do we have that document?
Yeah, it's right
I
here.
thought I had
just
submitted
wanna
it
make
with
sure.
there. It's an email from.
Oh, okay. From Mr. Artuso to the town supervisor and the rest of the board members. Okay.
Yes, correct. And some members of the public. And that's the first, I respectfully submit, that's the first notice that the public ever had. You can't file an appeal if you don't know what happened. And that's the first announcement to the public that this was going to be processed under an industrial use permit only.
Notwithstanding that, you would agree as a stipulated fact, if you will, that the portion that I read relative to the July 2025 resolution, that is as I stated.
I have no reason to
Okay.
dispute that. I
Yep.
don't know of
Okay.
personal knowledge.
Yep.
Questions from the board?
Yeah, Mr. DeMarco,
Yes.
I just want to make sure in my mind, would the published minutes of the town board count as notification?
I mean, above and beyond the resolution that was
Yes.
filed? I'm not, I don't know where do our minutes go?
They're on the web.
They're on the web, so they're available to the public? I would
Yeah.
think so, yes.
So, I mean,
Yeah.
the fact that they didn't say, hey, look at this, we've approved or decided this was whatever, that it's not necessarily published, but it is made public.
Yeah, I think that would be considered to be the public record.
Okay, thank
Yep.
you.
Other questions from the board?
I actually have two. The first one is, given the nature, and I'll call it the importance of the request that's being made of this board. All right, first, just a statement. I guess I'll voice my frustration that the additional information that we received from the applicant, that tonight was the first time we saw it, which doesn't give us any time to review it. So I'll just note that. But if this matter is currently moving forward with the Article 78 proceeding, should this board act at all while the matter is
Yeah, there's
currently in litigation, or are they two separate entities?
I guess, whether they're separate or not, the fact that there is a pending Article 78 does not affect our ability to make this determination.
Okay,
And our determination will have no effect on the Article 78.
Well, I guess that's up to Mr. Hanna,
Okay.
whether it does or it doesn't.
Other questions?
I'll be honest, I'm confused by what our role is here
Sure.
exactly.
So, as Mr. Hanna, I think, correctly wanted us to get our bearings, because it is true, we don't play this role very often, but it is a core responsibility of the zoning board to act as a review board for the actions of, in this case, Mr. Artuso, if he determined that something should or should not come before this board, or perhaps in this instance, whether he did not bring something to the attention of the town board. And so this board's being asked to review what it was that he did and make a determination as to whether or not he acted appropriately given the nature of the application. And I've essentially indicated to the board it's a two-step process. As in many things legally, the application has to be timely. It can't be stale. It can't be prohibited by a statute of limitation or like statute. And in this case, there is a colorable claim that it might be, or that it is. There's some ambiguity in the statute as to timeliness. So I'm bringing those to your attention to first decide whether it's timely or not. If you determine that it is timely, then you should consider Mr. Hanna's arguments and take a look at the law that's relevant to those arguments and make a decision as to whether you think that there was an error by Mr. Artuso.
So I'm going to try and give an example. A little while ago, this board was asked to make an interpretation on what is considered a front yard. When you have a property, I think was it last month or the month before, property had roads on three sides. Which one of those is a front yard or the front yard proper for setbacks, front doors, things of that nature. So that's one of the things that we're being asked to do is interpret the the use, whether a special use permit was required. I don't think there's any argument that this is in an industrial area, but it's more of whether a special use permit was required. That's my understanding. Okay.
Well, what happens if it's determined by this board that a special use permit should have been required?
Then the board's going to have to go back and revisit it.
The town board and the planning board.
Now,
But it doesn't kill the project, it just postpones it.
correct.
I mean, it could kill it. I mean, the developer might say it's too much time gone by. I mean, that is something that could happen, but it doesn't necessarily kill it.
Okay, thank you.
One more question for Mr. DeMarco. Whether or not Josh was correct in his assessment, the fact that the way I look at it, not being an attorney, there's a lot of technical points that Mr. Hanna has laid out, listed in his cascade of errors. So whether Josh was right or not, if it wasn't timely, it doesn't make a difference.
Well, I understand the question, and ultimately, in the course of the Article 78, a court could determine that the town board acted without the requisite authority, and that the court sends it back to the town to consider something that it overlooked, and that ultimately may or may not change the decision as to whether or not the town board issues those permits. Obviously, Mr. Hanna is hoping that that's the case, so that they feel that a more complete picture will end up stopping the project. It's to be determined if, in fact, they believe there was an error made, or this board determines that there was an error made.
Thank you.
So if this matter were discussed in the July 2025 town board meeting, is it possible for us to pull up those minutes and read that resolution into the record so that we can see what was exactly said? It's not information that I would normally.
If this board feels that it does not have sufficient information this evening to make a determination, and you indicate such, then we can take steps to make sure that you have what you need, assuming it exists.
I think we need to see those minutes, whether we review them now or review them. Probably reviewing them in detail would make more sense, but it is published on the town website, but we would certainly need time to review it.
Okay. Obviously, if
Maybe we can, I don't know,
that should come
take a
through.
pause and do it now, or I don't
Well,
know.
that should come through a motion, if that's what the majority of.
Well, yeah. So I guess, and Corinne, I was actually thinking the same thing, right? It's, man, I
I'm
have.
scanning it quickly, but
Well, it's not even that, right? I think to your earlier point, the documentation that was provided to us 5 minutes before we started this meeting. I understand that there's the email from April 1st, 2026. I have no idea if there's any previous documentation, so I can't sit here and say that there was.
Well, I can tell you that I had asked, and I don't know how comprehensive or complete, but I wanted to determine whether there was emails from the department. Again, I'm not saying that an email from Josh is dispositive of the notification issue, but I have not yet been provided an email essentially on topic prior to the resolution of the town board.
Well, backing both Mr. Short and Ms. Volo, I'd like more time to go through the resolution, because I think I'm kind of hanging it on a very technical issue, whether or not that was the clock started then, last July, or was past April, makes a big difference.
And I'm glad that you all had indicated, I thought maybe I was missing the April 1st email, so now I know it just arrived. So, look, I can't quarrel with that. It's potentially, something that's going to make your decision a little bit more clear.
We can table this, right?
So,
Sure.
so I guess before we table it, I guess the other question I have while we're sitting here, right? I mean, so that's issue one, right? And we can make a determination on whether it was timely or not. The other issue at hand is, it's kind of the actual issue, is the interpretation of the zoning interpretation as well. If we've determined, again, Mr. DeMarco, if I misspeak, please correct me. But if we determine that if it wasn't, that this isn't timely, we could stop there and not make a determination on the zoning interpretation. However, we could theoretically skip that, still make a determination on the interpretation if we wanted to.
Correct.
So I guess I have questions for the board regarding the zoning interpretation. Has the board had an opportunity to read through and understand Mr. Hanna's take on it? I know I've read it last month. I've reread it this month. I do get hung up on, is it 150-6, where it says a special use permit is required for residential areas. I get hung up on the fact that when you're talking industrial areas, industrial areas do allow, I think it's energy generation, if I remember correctly. I'm looking for it right now. Public utilities, right? So I guess and I don't know, all the solar fields that are out there, when they're now tied into the grid, is that technically a utility? So those are questions that I have, that I've raised for myself, and I don't know if anybody from this board has had kind of similar or not.
I agree with you on that. It's still interpretation.
Sure,
I mean,
and that's what this board is for, right?
But I'm saying it'd be much easier if it were cut and dry, one way or the other. And this
We wouldn't have a job.
No, that's fine with me. I'm okay with that. But my own opinion is, let's wait. I'd like to see us wait. So, this way, we don't have to necessarily go through an entire debate on how we interpret it, unless we really have to. My only other question is we still going to open, if we decide to table it, we still need to open up to the public for comments, don't we?
I don't think so on the appeal review.
Okay,
It's a different kind of application.
okay, there's a lot of people here, I didn't want them to necessarily.
But it's my understanding, for an interpretation, it's not,
Okay,
we don't have to.
well, they need to know that now.
Understood. So, okay, so I guess I'm going to ask the board, before we put it up for a vote, do we want to table this matter? I mean, that's kind of what I'm hearing.
Yeah, I say yes.
Okay, I mean, is it, Eric or Corinne, are we able to, those minutes, are you able to, I'll look for them on the web, but is it possible to get those sent out to us?
Yeah, because they're right online.
Yep, okay.
But we can send them.
Yeah,
Yeah, it'd be easier.
please, thank you. So, Mr. Hanna, at this point, and we're going to I'll make a motion that we're going to table this matter until the July meeting. Again, you provided some additional information kind of today, which I know me personally, I didn't get to see that. I probably would have asked for some of this additional information earlier. But with that, we're.
I might add it's actually good information
It
to
is.
have.
It is.
So
Absolutely.
I think you did a really good job for the few minutes I had to review it of presenting your case and what you saw as the pertinent points. And I'm going to parrot what other people have said. It's just unfortunate we didn't have a chance to digest it versus just reading through it really quickly before the meeting.
Is there any additional information that would be helpful to the board that I could provide?
Any questions for Mr. Hanna? No?
Not yet.
Okay.
I guess I would ask if we do table this to the July meeting, if there's any additional information that you have for the board, please give us at least a week before the meeting, to preferably two, but at least one to review it. Just so that we don't do the applicant a disservice as well, so.
So I'm going to make a motion to table the zoning interpretation located at 139 Caracas Drive until the July 14th? July 14th zoning board meeting.
Second.
Mr. Short,
Aye.
Mr. Santola,
Aye.
Mrs. Bolo,
Aye.
Mr. Miss D'Amelio,
Aye.
Mr. Corsi.
Aye.
Mr. Hanna, tabled until July 14th. Thank you.